Picture the exact moment the 2025 return to office order landed for you as a DC federal employee, or the moment a divorce filing arrived right after you spent the last few years building out your professional life at home. You're sitting there staring at your dual monitors, your standing desk, a client list you meticulously built, and a domain name generating side income. Your reality has just shifted. The immediate question is whether any of this still belongs to you. By the end of this explainer, you'll know exactly which of these remote work assets DC courts treat as shared property and how those assets actually get valued and divided. Here's the legal roadmap we're walking through today. We're looking at the new remote work reality, your physical home office equipment, hidden digital marital assets, valuing a virtual business, and finally, protecting your remote assets. Section 1. The new remote work reality. DC follows equitable distribution under DC Code Section 16-910. This means anything acquired during the marriage counts as marital property. It doesn't matter whose name is on the account, it doesn't matter who actually used the item. Roughly 162,000 federal employees work right here in DC. The home offices built between 2020 and 2024 by these professionals are a recurring issue in local divorce cases right now. Section 2. Physical home office equipment. Clients ask me all the time, is the equipment in my home office, my desk, my monitor, my chair, actually something my spouse can claim half of? The answer is yes. Physical equipment bought with joint funds during the marriage is marital property. Courts treat this personal property exactly like your living room furniture. As you break it down, standard items like computers and desks are valued at their depreciated fair market value. Higher-end audio or visual gear might actually require an appraised fair market value. The court's job is identifying it, valuing it, and distributing it equitably. Home office equipment gets valued at its current depreciated worth. We do not look at what it costs when it was brand new. A laptop bought for around $2,000 in 2022 might carry a present value closer to $600 to $800. Every single piece of equipment has its own depreciated valuation. But what if your employer issued you a laptop and a second monitor for remote work? Does any of that count in the divorce? There's a clear legal line here. Equipment issued by an employer always stays with the employer. It's not considered part of the marital estate. Documenting exactly what the company provided versus what you purchased personally is critical. Section 3. Hidden digital marital assets. This brings up a massive blind spot. Say you built a site business, a monetized account, or bought software licenses during the marriage. Can your spouse claim a share of that? Digital assets get overlooked constantly, but software licenses, domain names, and monetized social media accounts are still marital property subject to division. They hold real value, even if they rarely show up on a standard asset list. Section 4. Valuing a virtual business. How does a court even put a dollar figure on a used laptop or an online business? It's a highly structured process. The full article breaks down exactly how a virtual business gets valued using the income, asset, or market approach, and when it's worth bringing in a forensic accountant that's linked in the first comment. The crucial point is understanding the difference in goodwill. A virtual business gets divided quite differently from its equipment. Courts recognize enterprise goodwill, which is the transferable value tied to the business's systems and client base, as divisible. Meanwhile, personal goodwill tied to one spouse's individual reputation generally stays out of the marital estate. Section 5. Protecting your remote assets. You might be wondering, does the 2025 federal return to office mandate change how any of this gets divided? Simply put, no. The mandate did not change DC property law. Unused home office equipment remains marital property regardless of its current use. This brings us to the most practical step. What should you be doing right now, before the case moves further, to protect what you built? You must document everything right now. Gather purchase receipts, software licenses, business financials, and domain registrations immediately. Do not wait until after the case is filed. Courts rely heavily on an accurate, chronological paper trail. Equipment, software, and even a side business built during the marriage are usually marital property in DC, and protecting them starts with documenting everything now, not after the case is filed. The full article covers how to update a prenuptial or postnuptial agreement and how to request a temporary order before assets get moved or hidden. That's in the first comment. Subscribe if you want DC family law guidance like this without having to search for it every time. I leave you with this to consider. If your spouse subpoenaed your payment processors today, what would your financial disclosure actually show?